My name is Arjun. I'm a product marketer with Zoho Contracts. Uh, this session is about PDPL, the new personal data protection law that is going to go out in Saudi Arabia. And these new data protection regulation will become very important because the regulations are stringent and the penalties are huge. But more importantly, whenever there is a new regulation coming up, like data privacy or data protection regulation, the early adopters gain that customer trust, which eventually becomes their competitive advantage, right? So it is very important that businesses take these regulations seriously and implement them as soon as possible. So in today's session, we are going to dive deep into the PDPL in KSA, right? So we have Andrew David with us. Andrew David heads the privacy program at Zoho. He has been with Zoho for the past 6 years. In the 6 years, we at Zoho we have gone through a lot of new regulations, right? And we are a global company. We operate in a lot of geographies, and each regulation is different. So Andrew has a rich experience in educating employees about compliance and conducting regular audits, security audits, compliance audits, and also designing processes that will enable compliance, right? So in today's session, Andrew will share his expertise, which will help us understand what PDPL is and how to implement it for the businesses in KSA, right? So thank you so much, Andrew, for taking the time out and being here with us. So I will also touch upon what will be the agenda for today. So we will start this session by explaining what is PDPL. We'll give you a PDPL overview, and we'll take you through the key aspects of PDPL, and we will give you an implementation checklist of PDPL, how you can implement PDPL for your organization. And throughout the session, across these different aspects, we will also keep comparing PDPL with the other previous data protection regulations that has gone out. Right, so we have experience handling GDPR, CCPA. So all that learnings we are trying to relate it with PDPL, and we'll tell you how that can help you. And the second half of the session will be focused on contracts, right? So whenever there is a new regulation coming up, businesses are forced to change their organization wide policies, which will eventually translate into changes in your clause languages, right? So this change involves mass changes on your contracts, on your existing contracts, and on your future contracts. So we will touch upon how this PDPL will impact your business contracts, and we'll also cover how a digital contract lifecycle management solution makes it very simple. So we at Zoho, we have recently launched a contract lifecycle management software. This is our first product in the legal domain. So it is also partly introducing Zoho contracts to you. That will be the last portion of this demo. So this will be the agenda for today. And I'll start with a small disclaimer. This is not a legal counsel or legal advice, because we, both Andrew and me, we are not lawyers. What we are trying to do in this session is we are trying to tell you how you can implement business processes that will help you achieve compliance, right? Because since we have handled a lot of data protection regulations at Zoho, we are sharing our experience with you. We strongly suggest you consult with your legal counsel before you actually implement PDPL for you. What this session will do is it will inform you on the scope of PDPL. You can make better informed decisions while you're having that conversation with your legal counsel, right? So with that, we'll get started. But before that, I want to run a few polls to understand our audience better. Because if we understand the audience better, we'll be able to cater this session based on the audience profile, right? So the first is we wanted to know from which sector are you coming from, right? So I'll start the poll. Please help us with your answers. Yes, thank you. So first, I'll hand over the session to Andrew. Andrew, if you can start with what is PDPL and what is the scope of it, who are going to get impacted by PDPL, and then if you can also touch upon what is the implementation deadline. And from your experience, you would find subtle nuances, subtle differences from the previous regulations. So please take it forward, Andrew. Thank you.
Sure. Thanks, Arjun. Thanks for the introduction, and it was a good start for today's meeting. Um, so, well, I recall this instance where we had an internal meeting with our all of our board members, where we were discussing about the different laws that we were complying, and one of the senior executives said that, you guys are bringing a lot of problem in our lives. We were doing business much better than how we were before, but due to the increasing number of regulations, you guys are coming up with new laws, coming up with new processes, more restrictions that we really didn't think, and it's making life difficult. Well, I think that is where most businesses find themselves today, especially when they are global and they have a global audience, and they uh, look to cater to a greater part of the world because they have a solution, they have a service that can impact the lives of so many people, not just in a business context, but they have a good offering, right? So, and that is something that is inevitable because when we do operations for a given country, there has to be some guidelines, there has to be some rules, and welcome to the KSA's PDPL. So that is something that is the latest in the market of data protection in the whole world scenario. There are many others as well. Like in the US, there are the Utah Privacy Bill has been recently passed. In Virginia, that has been passed, and there are so many others that are evolving. But uh, KSA's bill, which is Saudi Arabia's PDPL, has taken the front stage, the front portion of the stage, or the center stage, I'd rather say, because that the date of enforcement is coming quite near, which is going to be 23rd of this month. Just maybe about 5 days from today is going to be in force. But yes, the good news is that it is not the date where you have to comply fully. Good thing the regulators understand that businesses are not meant to be fully legal all the time in the terms of they can't be thinking about complaints all day long, so they need some time to get accustomed to that, get their process right. So they have given about a year's time for compliance. So that's good news for most of us because it is coming into force on 23rd of this month, but you have about a year's time to get all of our processes, all of our procedures and our contracts and everything fit to be compliant with the law. So which is the great news about uh, at least the deadlines that we have. So I think a reason why I wanted to put that first was because if we take our minds off the tension of getting compliant, we have about a year's time. So
Got it. Yeah.
unwinding ourselves from that. Yeah.
Yeah, very true, Andrew. When you said people perceive it as a pain, any new regulation as a pain, but the law seems to put its intent very clearly. The intent is to protect the data or the personal data of the residents in KSA, and it is also consistent with their larger vision of Saudi 2030, where we are aiming to build a thriving digital economy. So it all comes in line, and all the signals indicate that they are going to bring in this regulation seriously. And so before we step into the actual regulation, Andrew, what constitutes as a personal data?
Right. So as it goes with any regulation, the terms are quite well defined and quite specific. Um, but yeah, there are a few. Like for example, the Europe GDPR is quite large definition. So for example, even IP addresses, those kind of information that we even cookies for that matter are constituting personal data. But I think the PDPL is quite even more clear on the definition of what personal data is. So it just simply says that any information that is going to relate to a person is going to be personal data. So to be more precise, any statement, whatever its source or form, that would lead to the identification of an individual, and either be it through direct or indirect means. And they've also given some examples of what it could be, such as like the name, the address, the contact numbers, the driving license records, personal property records, bank records. I think even specifically they mentioned credit card numbers and photos also. So that is an interesting thing that I saw because uh, so far from all the definitions that I've seen regarding personal data, they don't explicitly mention about photos. They talk about minuscule objects that can be used to relate to a photographic image of a person. They are very complicated, but I think the PDPL does a good job in defining what person it is. So if you can
Got it.
identify a person with the data either indirectly or directly, whatever that means is going to be, it constitutes personal data.
Got it. Yeah, thank you for that definition, Andrew. So also, attendees for the during the course of session, we'll use terms like data subjects and data controllers. So Andrew, if you can also touch upon what a data subject means and what data controllers mean, we can then proceed with our session.
Sure. So when you talk about controllers, controller is a public body or any entity, either private or public, be it in your natural or legal capacity. As in, it could be as a single person who's processing another person's data, or a company and an organization processing a person's data, is deemed to be a controller. I often relate that definition with the Xboxes and the PlayStations that we play with. Right, the controller that we have in our hand, we basically tell the 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 microchip that is within that to do something, right? So I tell you to go right, my object on screen goes right. I tell you to go left, the object goes left. So that is a very similar definition of a controller. Any person or any organization that determines the means and purposes of processing. Means and purpose, to be slightly rephrased, I'll say why and how a data should be processed and why it should be processed. Whoever makes that definition or whoever makes that decision of determining what to do with the given data, how to do it, and why, they are going to be called as the controllers. So you can, like I said, the example, you can probably relate it that way so that you understand it throughout the session. Controller is someone who tells what to do, how, and why to do. The processor is just the other portion of that, where you have a microprocessor. Being from Saudi, right? That region, we are well known for being good in electronics. So microprocessors are those things that perform something. You give an input, it gives you an output. So input is coming from the controller. Processor does something on the request of the controller and gives some output. So, but in PDPL, the exact term that they've used is a processing party. They don't call it as a data processor by itself, but you find the words very similar. So processing party is the term that is used. So controller determines why and how. Processor does that according to what the controller requires. So this is going to be the two major keywords. Other thing is a data subject, which is the person whose data is going to be processed. So be it normal people like you and me are going to be the data subjects, to whom whose data some other person or some other company, also called as a controller, is going to process.
Yeah, thank you, Andrew. So basically, the person whose data is being processed is the data subject. The organization or entity that controls how and why this data is processed is the controller. And if they are using any third party or other parties or individuals to process this information, they are data processors or processing parties as per PDPL,
Exactly.
right? So now, we wanted to tell you that the regulations are going to keep coming up. So once you implement one regulation like the PDPL, and once you have the framework ready, the rest of it is comparatively simpler with inference, because you would have already known how this framework works, right? So now we are moving to the key aspects of PDPL. So Andrew, when we talk about a data protection regulation, right, immediately the word comes to my mind is consent, right? You have to get the consent of the parties to collect their data, right? So that becomes a lawful ground to process their data. But apart from consent, are there other lawful grounds for processing data? Or yeah, so can you please explore this thought?
Yeah, I mean, the word consent, I feel, is the most abused and tortured word, because most of them, we often find that word misused, actually, because consent is a property that gives a lot of control to individuals. But unfortunately, many companies misunderstand the definition of consent, and they consider even normal authentication or an authorization equal to consent, but that is not so. Consent is very specific on what its requirements are. Uh, Likewise, in the PDPL, consent is the topmost lawful ground. So, what is a lawful ground? If you need to do something with a data, you cannot just do it out of the blue and out in random. You should have a reason. You should have a legal backing for that. You cannot just do it just because you feel good doing it. You should have a legal reason for doing that. So that is called as lawful grounds. So consent is the topmost used lawful grounds when it comes to PDPL. There are a couple of others, some other lawful grounds as well, but actually, when we see through the whole regulation, when we go through the entire law, we come to a conclusion that probably consent is the only way to go ahead. I'd say that like around 70% of the cases for a normal company, like for example a SaaS provider or someone, not in the health sector exactly, but a sort of a normal IT sort of a vendor or anyone for that matter in that space, they would ideally have to resort to consent to being the topmost or the most used lawful basis or lawful grounds for processing data, uh, because the other ones are more of a vital interest for a person, as in like a life or death situation, or in the scope of a public interest, which is more of for a news research or statistical approaches, or for due to this COVID pandemic, maybe publishing the data of how many people have been vaccinated. Those kind of things are done in public interest. So those are some of the other ones that can be used, but unfortunately, for most companies, we would not find ourselves in being able to use the other ones as very frequent compared to consent. So maybe we could conclude that consent could be one of the most used in a normal company's uh, daily use of personal data. But there are others, but which are more towards public interest and vital interest, and those kind of health and safety of the public, and those kind of other security, like national security reasons, or those kind of things. So yeah, or if the data is publicly available, like for example, if the data is publicly available in the source of, say, um, um, government records that have been made public, where possibly you don't need consent to process that. But again, if you just take a normal company, you would not encounter situations where you would use publicly available data, because someone has to give you the data to get the job done. So yeah, consent is the biggest one. Slightly, there's a difference here with respect to GDPR. Is that GDPR allows something called as the legitimate interest of the controller, but unfortunately, the PDPL does not give lawful basis such as that. So it's going to be a slight challenge when it comes to processing data for corporate purposes. We'll have to still rely on consent as the primary lawful grounds.
Yes. So before we move on to the next aspect of data transfer, attendees, we would like to know how many of your businesses involves processing data outside of KSA. So I am running a poll uh, to check if your business process involves transferring personal data of KSA residents. Based on that, Andrew can dive deep in or touch upon this topic. Yes, the votes are coming in. Thank you. Yeah. So, Andrew, it looks like more than 40% of the attendees do have a business process where they have to, transfer data to process. It's part of their business process. So, when it comes to data transfer outside of KSA, and also if you can touch upon how internal data sharing works, it'd be helpful.
Sure. So when you talk about data transfers, the Europe has been very stringent in that. So when we have to transfer data outside of Europe, then the recent shrimps to the case law and all of that comes inside. So there are very strict rules already because of the GDPR in terms of Europe. Similarly, for Saudi Arabia, the PDPL also prohibits transfers of data outside the kingdom unless certain criteria is met, and more of those criteria is towards the well-being of the kingdom and for the in the interest of the kingdom. So probably data transfer should be as much as possible limited to only those that are necessary. But there is one good thing, is that if the data subject consents for the transfer, if they are okay for transferring their data outside, uh, uh, for a given purpose, such as for using a cloud provider or something, where they agree to the terms and the privacy policy and all of that, that should be fairly allowable. But just transferring data just because we are having not being able to process it locally is not going to be an excuse. So having transferring data outside, uh, is we are looking for more information on that because the regulators have not been very clear on that. But it looks like I'll call it likely. It is more likely that we should avoid transfers as much as possible with a certain exemptions that are already given in the law.
Yeah. So, Andrew, are there any clear guidelines on if you are going to transfer this data, you have to register with this authority or you should have a local representative? Is there something like that that's clearly defined in the PDPL?
Yes. So there are requirements to have a local representative, say, because we saw in the poll that there are regions, there are companies who are international companies who process data of Saudi Arabian individuals, residents who are there outside of the place where their data is actually located. So, say for example, a US-based company providing service to Saudi Arabian residents, but their data is primarily processed in the US. So that being the case, that other company, whoever is going to process the data, also called as the controller, should have a local representative who is a local resident of the Kingdom of Saudi Arabia. So they should have a person or an entity that is designated to be a local representative of that company. Let's call it XYZ. XYZ US is one entity. They should have an XYZ KSA entity as well. So that is one of the requirements when it comes to having representatives. Yes, you asked another question about registration. So yes, there is a requirement. Probably we'll look into that as
Got
we
it.
go forward.
Got it. Yes. So moving on to the third aspect of data subject rights, Andrew. So any data protection regulation gives the data subjects a lot of rights. Is it the same set of rights like the right to access data or updation, or are there other rights that are special to the PDPL?
Uh, um, I would summarize that into more four rights, ideally, because the right to access, the right to rectify incorrect information, and the right to ask the data to be deleted, and the right to be informed of the lawful grounds of processing. Right. So these are going to be the top four rights that are like the prime of what the PDPL has provisions for. Uh, the right to object or the right not to to restrict processing, those kind of things are not explicitly defined, but as we see and we read through the law, there's this common thread that runs that just says that whatever you do it properly. So that's going to be the the take home that we do. So explicitly the four rights are the ones that are quoted, but the right of objecting to or right to restricting of processing whatever is given as GDPR. I'm just drawing comparison because it's the stringent law. So that is not explicitly defined in the PDPL of KSA.
Yeah. So, Andrew, you mentioned obstructing the data processing or stop processing data. So, if a customer demands that you stop processing data, is it the same as them asking us to distract their personal data from our systems?
Ideally, that won't be the case because, say, for example, I'm sending you an email, marketing email. I have your consent and I'm sending you an marketing email, and you object to that, basically withdraw your consent. Um, Say, for example, I have to keep a record of that for a longer period of time due to maybe a telecom regulation or due to maybe some other regulation that interplays. Because we know that there are other regulations already in Saudi Arabia, which is the CITC's computing cloud computing regulatory framework, CCRF. Also, the current one that is existing, which is the personal data protection interim regulations, I believe, and the IoT regulatory framework. So there are many frameworks already. KSA has a lot of sectoral regulations already. So as long as it's not conflicting or contrasting or not conflicting with the other regulations, you can keep the data if it is required by those regulations. But if you don't have a lawful reason to keep it, you just got it from somewhere, you just sent someone an email and they told not to, then ideally you don't have a reason or lawful ground to retain the data for a longer period of time. So in that cases, it would ideally deem deletion of data because there is no reason for us to keep it.
Got it. Yeah, Andrew, you made two interesting points. Like when you were talking about this part, you mentioned even though the law does not explicitly mention it, it is ideal to remove the data if you don't have a legal basis to retain it, right? Even this one, and when you spoke about the data subject rights, you mentioned the underlying current or the underlying theme is to ensure fair use of data, right? So this takes us to the fourth aspect, that is transparency. So how to ensure transparency? One usual way is to put out a privacy policy that's comprehensive. You commit the regulations in the privacy policy and you share it with the uh, data subjects, right? But from whatever you're mentioning, there are not clear provisions on how to completely ensure compliance, right? So are there cultural elements on how an organization should think about privacy? Are there cultural elements on how employees should think about privacy in itself? So I think that that would be helpful, Andrew.
Sure. Like rightly said, having a privacy policy is the first step in ensuring transparency. And the PDPL in Article 12 has a very specific mention saying that the controller should have a privacy policy and it should be available before you collect someone's data. So having a privacy policy is the first step, but that is not the only step. There's something that we internally call as contextual compliance. So at the point of data collection, at the point of processing, wherever possible, make things known to the people, because privacy is not about secrecy as such. It should not be confused with that. Neither is it confidentiality by itself. So privacy has its own space with respect to users and their rights and their knowledge of what their information is and what how it is being processed. So transparency is like the overall core of what privacy regulations generally require. So transparency could be established through maybe systematic alerts, like in the products, like having to add a privacy policy or a cookie banner. Those kind of things are also ways to achieve transparency. More culturally, I would rather say, if the employees of a company are given privacy for their own work, in terms of at least their personal data, their family data, and all of those things. They get into a culture of privacy, which in turn reflects on their work. So that is what we follow here at our company, right? So we, as much as possible, we try to reinforce it subtly to employees so that it becomes a part of them, part of their daily operation. So cultural aspects has a lot of importance on that, rather than just being a compliance checklist saying that I have a privacy policy. Yes, it does not stop there. It is more of a cultural change and organizational mindset change that also makes a lot of difference.
Got it. So also considering the penalties that come with non-compliance, I think imbibing that culture of privacy will help us stay compliant for the long term rather than just implementing PDPL right now. So when we talk about implementing right now, you spoke about a lot of aspects of PDPL, Andrew, and now if you can touch upon how to systematically implement it for a business. So for our attendees, if they have to go and implement PDPL, where they can start from. So with that, you shared this personal data cycle. So what are the touch points here, and how in each of these stages the attendees can ensure compliance?
Sure. So, right, we just saw, the lawful grounds is going to be consent. So that calls for a proper, I'd call it as a CMF. In industry, it's called as the consent management framework. So being able to record consent the right way and to be able to track it back in time. So when did a person give consent? Through what means? Was it through a web form? Was it through an email? Was it through a phone call? Having a record of that, that's going to be the core of your consent management framework. And consent should be that is given once should be easily revocable. So we cannot trick people into giving consent and not letting them to take out. We should. That's where transparency also has some implications. So having a consent management framework, a properly thought out consent management framework through all of the data entry points is going to be an important thing. After that, like we know, data has to do with collection to destruction, all the phases that it goes through. So I'm just going to collate all these points, like from say 2 to 6 that you see on screen: collection, storage, processing, sharing, and transfers. So right from the point of collection, security starts coming inside. So the way that you protect the data on storage, so encryption of the data on storage, having to limit access controls to the data that is stored is an important thing. Processing it only when it is necessary, not, for example, just imagine a CRM system or something where you have thousands of records. You can easily put a filter, take only the necessary records and process that. You don't have to process all the records just because it is there in the system, right? So that Now, that is one practical way you could do it. Add filters wherever possible, add screens, add reports, take pseudonymous or take anonymous data wherever possible. Don't go for personal data everywhere. Avoid duplication of data. Those are some thumb rules that we can actually follow. If we duplicate data too much, when a request for erasure comes, or a request for deletion of data, that's going to be a hell of a lot of mess because we won't know where the data is going to be. So through the life cycle, tracing out the data, where we are collecting it, where we are storing it, how much of security has been given for that, and to whom all we have disclosed that, and at what points of time is going to be an important aspect. Finally, the incident and breach response is also an important thing because the PDPL has a special provision for notification of a breach. In case a breach happens, you should notify the authority immediately. So, what is immediately? Well, everyone has a different. Like for example, we make fun of ourselves saying that you have come in Indian Standard Time while I call you the Arabian Standard Time. Sort of, because we come late for a meeting or something. So immediately is not subjective. It is simply meaning that once you come across this, once you are aware that a particular thing has happened, something has gone wrong, that a potential leakage has happened, you should immediately notify the authority. So the GDPR says that you should do it without undue delay, but less within 72 hours. They have given some numbers, but PDPL does not give any numbers. It just says that you have to do it immediately. And if the data that has been breached is going to affect someone's life in terms of a mental way, for example, it may cause them stress. For example, if it's a financial data, if it's a password that to their bank accounts, it's going to have a lot of emotional trauma as well. So that risk of harm also has to be thought about. And if that risk of harm is high, we should be notifying them as well. So yeah, just thinking through the entire life cycle of data and considering that special case where it is breached is also an important aspect.
So, Andrew, when you say breach response, we have to intimate or we have to inform the authorities as well as the data subjects if the harm is high. Is that
Yes,
what you mean?
that is
Right?
right.
Yeah, got it. Yes. So we'll move to the actual implementation checklist, uh, Andrew.
Sure. Right. Uh, well, I would again just summarize whatever we just saw so far because all that we've seen so far has to do with at the end of the day boiling down to well-known points that we can implement. So the first thing is training. The reason is if employees are not trained to handle the rights of data subjects, if they are not able to identify a potential breach, then that's going to be a big problem. You can never stay compliant with that law. So employee training, getting everyone on the same stage, on the same platform is the first step. That you can have an internal meeting within your team, just brief them about whatever you learned from today's session. So that could be a good starting point. And that should be consistent. This is not a one-time activity. So that's something, right? Do it and forget it. It doesn't work that way. The second step is the data mapping, which is the data flows document. Some call this the DFDs, data flow diagrams. So basically, what data does your organization collect, and from whom? Where do you store it? Who has access to it? To whom have you disclosed this to? So basically, the circle which we just saw in the previous slide, just put that into a document. What data do you collect from whom? What type of data? Whether it's sensitive data. Sensitive data is like more of the religious affiliations, political opinions, genetic data, biometric data are all sensitive data. So if you collect that, then probably you should. There are additional steps for that in terms of compliance. So having a record of what data you collect, where you store it, is going to be the second most important step. The third is documentation. Actually, the PDPL has a very specific provision for documentation. It says that you should have a record of all of your processing. So, what are the data that you process? On what times do you process? There are, I think, 4 or 5 points that have been mentioned in the law. It says that the controller's contact details have to be there. What type of data you're going to process, to in what countries the data is stored, and all of that. So there are about 4 or 5 pointers that are there. So having a record of that is going to be important because the regulators might ask for that during some audits or some evidences or inspections. So make sure you have. It's also called as a record of processing. So make sure you have that documentation. Then just recollecting what we just saw, data protection policy and the privacy policy is important. A subtle difference between both is that a privacy policy is also called as a notice, is more external facing, it is to your customers, to your clients. But a data protection policy is internal to your organization, wherein you give your standard way of approaching something and you educate your employees on that. Say, for example, how to identify a breach, who are the contact points within our company. So all of that is going to come under a data protection policy. Never, send marketing emails to someone without having their consent. Is going to be a statement within your data protection policy. This is all internal policies. So your acceptable use policies, your incident management policies, everything would come under data protection policy. Your Then the next step is to review the breach response mechanisms, because we should be ready for the worst because we will never know. So there's this joke, or basically a truth rather, that is said in the information security domain. So there are just two companies in the world, ones that are already hacked, the others who just don't know that they're hacked. So that is the reality. We really don't know sometimes. That's how much the digital world has evolved. So we have always have to be prepared for the worst. So BCP plan, disaster recovery plan, business continuity plan, and breach response plan should be in place. So which authority to contact, how to contact the authority, what are the authorities phone numbers. Having a record of all of that is going to make life a lot easy. Finally, it has to do with reviewing our customer contracts and our vendor contracts. So ideally, when we look into contracts, there are some important provisions that will be there. Probably I'll tell that after some, I mean, as we progress. But contracts become a very important part when it comes to managing compliance, because just uh, like we just saw in the beginning, the definition, right? So the controller alone does not take care of everything. There is another person called as a processor, and in reality, there's more than one processors. One person cannot do everything. One company cannot achieve everything. So they in turn contract with others, contract with other parties to be able to go forward with their work. So having a contract, a written established contract, is going to be important. And obviously, your customers are going to have contracts with you, very specific languages on compliance and all of that. So contract reviews are going to be an important step that companies have to take as part of their PDPL compliance journey.
Yep. Yes, thank you, Andrew. That was a comprehensive implementation checklist. So, when you spoke about contract reviews, now we come to the second phase of the session where we just talk about the impact of the PDPL in existing contracts. So it's not just the PDPL. Whenever a new regulation comes up, all our existing contracts are going to get affected, right? So, any new regulation, the state regulation, will impact some of the organization-wide policies we have, and all these policy changes will reflect as contract language changes or contract amendments in our existing contracts. And I think the PDPL also has a provision for contract reviews, if I'm not wrong, Andrew.
Yes. So yeah, Arjun, this is one request also, is to request you to mute your mic. It's from one of our members as well. Like when I'm talking, seems there's
Yeah,
an
good.
echo. Yeah, thanks for that. Perfect. So yes, having contracts, like you just saying, is an important portion of ensuring accountability. The way that you ensure someone does what you do and confirms that is going to be through audits. Is going to be through audits. How does audit happen? Unless you have a contract, you cannot have an audit. You cannot just walk into someone's house. It's equal to having a warrant. You should have a warrant to do something. Similarly, contracts become so important to business relationships, like between customers and between your vendors, that you have a legal right to actually ensure that the other person, which is the other controller to whom you're transferring, or the other processor to whom you're transferring the data or working along with, is also compliant. So in industry, we call that to be as a flow down of obligations. Flow down of obligations. So what does it mean? Is that it is not sufficient if you take all of your responsibilities on yourself, but in the supply chain, everyone else should be on the similar stage. They should have the PDPL has a very specific portion for that. That you should ensure that you choose such kind of parties who guarantee a minimum level of protection. I'm not able to exactly recollect which article was that, but it says that when you contract, when you plan to use any party, you should ensure that they are able to provide you with the necessary protection for the data. Protection as in security and compliance and privacy, all such kind of protection, even legal protection for that matter. For example, an authority coming and asking for a data, like a data some due to some terrorist activity or something, they want the data, right? So that also has to be legally protected in a way, in terms of it, that request has to come through legal means. It cannot be just through a normal email or something. Maybe it has to come through court. So protections, that is what is meant by sufficient protections. Securely protected in terms of security, privacy is protected, the compliance aspect is provided, and the legal aspects are provided. All of this is taken care through contracts. Contract language defines a lot of that. So I personally have been part of so many calls with our customers on special provisions of contracts. So what are the I'm just going to give some highlight on what are the different clauses that should be there when it comes to contracts. Like for example, um, limiting data transfers could be one of the points in the contract. So then your right to audit your vendors could be one of the contracts. One of the clauses in the contracts. Then ensuring that they have necessary security measures is going to be another important clause in the contract. Then say for example, you're using a third party HRMS system or such kind of a system, right, or CRM system, then that application should be able to help you adhere to the data subject rights. If someone comes and asks you as a controller to provide a copy of the data, which is their right of access, then the company where the data is being hosted and processed should be able to provide you the data either manually or through the user interface screen. Anything could be the case, right? So you should ideally put that into the contract, saying that uh, you are supposed to help me wherever possible to get this. And for example, even incident notifications, or if there's an investigation on your company, and obviously the investigation with how to associate to the vendors as well. So you'll have to need their help. They cannot just wash their hands off from this. Then for data deletion and return of the data, these are some of the aspects where we often find contracts having a lot of power, because they limit what other parties can do and what they cannot do. At the same time, your customers are going to have some requirements for you, like it's also called as obligations. So they are going to ask you to do certain things and not do certain things. Probably it's one of the biggest deals that you're getting, and you're accepting to a lot of clauses. You cannot just sign the contract and forget it. There are some things that you have to stay on top of. It should be assigned to stakeholders within the business. So that being the case, obligation management becomes an important part when it comes to contracts. So and contracts expire, right? So we cannot just forget contracts. It has to be properly renewed. So periodic renewals, being able to know what are the contracts that are signed in the last 1 year, what are the ones that are expiring, what are like contracts that have been perpetual in nature, like for example a long period, what are the ones that are in short period. Having a track of all of those things, being assigning people to those obligations, are also an important facet when it comes to managing and organizing our contracts.
Yeah. Yeah, you covered it wonderfully well, Andrew. It was very comprehensive. So when we think of the implementation part of contracts, right? How do we actually implement the regulation in the organization, and how do we ensure that the contracts are also coming along? The contracts could not stay behind because it risks non-compliance, right? So when we think of actually implementing a regulation in your organization, a lot of contracts are going to get affected. So as a business owner or as a contract admin, you will have to quickly identify how many contracts are actually going to get affected, right? If there is only one clause that is going to change, how do we exactly do an impact study, and how do we understand how much effort is required and how much time would we need to implement this change? So these are aspects where a digital software can help, because when you have a digital software, every interaction, every personal data, and every activity that is performed on the contracts is mapped to an individual, and it's also mapped with the timestamp. right? So every activity is tracked on all levels, at an individual user level, at an individual contract level, and on all of these levels, when you're tracking the information, it becomes easy for you to stay compliant, and it also becomes extremely simple for auditing, right? How do you ensure that these things are happening? You when you know when you have improved visibility with the digital software, you know that these things are happening. So I will quickly touch upon how these features will be relevant when you implement PDPL. So when I talk about the data protection features, right, just a second, I'll quickly share my screen and I'll take you through the product. Yeah, I hope you can see my screen. So this is the Zoho contracts page that you're seeing. So the first thing is the data protection features, right? So in all sophisticated contract management softwares, or in most sophisticated contract management softwares, there are these features that help you stay compliant to data protection regulations. So we have that feature called data protection settings. So what this helps is it enables you to define the fields that contain personal data, right? You can initially define what are the fields that contain personal data. Then you can restrict your non-admins from downloading these data from your system, right? You can also ensure that whenever a customer or a vendor comes to you and asks you to stop processing data or asks you to restrict their data, it becomes extremely simple, because if you go to the counterparties module, if you open a counterparty, and if you click on the more option on a counterparty contact, you will see this option called stop processing data, right? Without a feature like this, it becomes extremely hard to actually implement this contractual promise that you've made. You've told them that you will stop processing data on demand and you will anonymize data on demand. But without features that will actually enable you to do that, these obligations will become extremely hard to actually fulfill, right? So when you click on stop processing data, the tool stops processing this personal data from wherever it is there. And when you anonymize it, so when you delete a contract for logging purposes, right, you will have this instance of the personal data on multiple places. Say, for example, this person has completed a review, this person has added this comment. So all of these logs will still contain personal data. So if you have a tool that can help you anonymize all instances of this data, wherever that particular personal data is present, it is replaced with an anonymized number, right? So these features will help you ensure that you're actually staying compliant rather than it's only a promise on a contract document, right? So next aspect, we were looking at the impact study. So when you're going to implement a contract a regulation, you will have to edit a lot of your contracts. So to do an impact study, reports come in very handy. So if, for example, if this particular regulation is going to impact your data protection clauses, you can quickly search for the data protection clause from here, right? I don't have contracts that have data protection clause. For example, if you are going to change the assignment clause, the admin or the contract owner will be able to quickly know that this clause is present in 26 contracts. And you click on the data, you will also see the contracts that actually hold this clause, right? You can directly go to this particular contract and you can amend this, right? And when we are talking about an organization wide policy change, it means a lot of contracts will get amended. So this is where automation will come in handy, right? So if you look at the contract letters feature, so the contract letters are automated. That is, you can go to the contract document and start editing like it is any Word document. And this amendment letter will be automatically generated, right? So if you notice the amendment letter, there is a whereas clause and there is a now therefore clause. So the whereas clause will be automatically captured and generated. It will capture the entire history of the contract. When did the parties originally enter into this agreement, and what are the past renewals and amendments that has happened in this contract, and the now therefore clause will capture the current change. So since this document is automatically generated, you save a lot of time on paperwork and you can concentrate on the actual high value implementation work when it comes to PDPL implementation, right? And from then on, you can just send this contract letter for negotiation and signature, and you can keep all the counterparties and vendors informed, right? And then when you have to make changes, if you're a global company and data protection clauses differ from country to country, right? So the data protection clause in Saudi Arabia will be different from the data protection regulation in Europe because of the GDPR. So for this, you don't have to create multiple templates for your business contracts, all you have to do is you can create multiple languages for your individual contract clauses. So, for example, if you go to any clause, you can add alternative clauses and you can add alternative languages for each of these clauses. So, the data protection clause could just be one clause, and you can have the data protection language of all the regions, and this could be implemented directly within your system rather than you creating multiple templates for each of these geographies, right? So then comes auditing and governance, right? So you will be able to quickly revisit what happened when and who performed that activity. So every activity is tracked. So this is the user's profile. At the user level, the activity is tracked chronologically. You will know what change has made and in which contract. This is present also in the contract level. So if you go to a contract, I'll open this contract. So there is this activity tab which will display all the activity that is performed in this contract with the timestamp chronologically, and it will also tell you who performed that individual action, right? And you also have the activity logs. This will help auditing extremely simple. So there are admin audit logs that will give you what changes were made to the admin console. And similarly, you have user access logs. So you will know who are the users who are accessing your contracts, who are working on your contracts, and from where they are logged in. And since contracts contain a lot of critical information, personal data, you should keep a track on who is exporting this data. You should keep a track on who is downloading this data from your system. So you will know from the download logs who has actually downloaded the data from your system. And all these features will help you improve compliance and have better control over your contracts, right? So, and Andrew touched upon a very important point of obligation management. So when you are implementing a new data protection regulation, you are going to change a lot of things on your contract, but it's not a one time thing. You will have to ensure that you're fulfilling these promises, right? And how do you do that? So if you have the ability to track all of these contractual promises at an individual contract level contextually, and if there's a contract owner who assigns these obligations to the respective business owners, and they can periodically keep track of all of these obligations and their uh, progress, right? So this is the obligation owners window. So they can directly go to the obligation, and to know the context of where this obligation is sitting in, the business owner, for example, can click on the contract and go to the contract document and see the context in which this obligation is sitting in, right? So this improves compliance to a huge extent. So if you notice, here is the obligations module where you can track all the obligations present in this contract right within the contract. So these obligations could also be task obligations, non-task obligations. For example, if you have promised to conduct regular audits on your vendors, then you can create a recurring event, and that could be a task obligation. And if you have promised that you would not disclose, so for example, a non-disclosure agreement, the promise itself is that you do not or you will not do it. So it is a non-task obligation. Even those obligations could be tracked for compliance purposes, right? So when you're implementing the PDPL or when you're implementing any future regulations that are going to come up, your contracts are going to get impacted. So the early you start thinking about contract lifecycle management as a piece to stay compliant, it will be helpful for you in the longer run, right? So I'm coming back to the screen. Yes. Yeah. So we are also working on an ebook that comprehensively covers contract management and in the context of PDPL. So we are coming up with an ebook for PDPL for contract managers and how to implement PDPL for your contracts, right? So if any of you would be interested, please show us your readiness in the poll. I'm running the poll right now. Yes. Thank you everyone for showing your readiness. So with that, we've actually come to the end of the session. We have touched upon what the PDPL is, what are the key aspects that the PDPL has, and how to implement it for your business, and how it impacts business contracts, and how a digital CLM can help. Andrew, if you have some closing thoughts on what should be the primary takeaway for all of the business owners or the admins or managers who are here, it'll be really helpful.
Sure. Um, So, like I just said, compliance is not a one-time activity. It is an ongoing activity where we have to ensure compliance at all times. So, having to take, I'll probably just give three takeaways. Is that make sure your corporates are ready for it, so that like for example, your budget readiness for it and all of that should be, and your human resources should be ready in order to comply. So, start with a good training, a good primer to your employees so that they understand what this is, not more of a compliance exercise but rather as a culture. So that is the first point. Second is work on the compliance aspect where you are lacking, which is basically do a gap assessment. You might already be compliant with a lot of laws, so find out where you are missing, what are the things that you have to additionally do. And third start reviewing your contracts, because as we know, when we work with a lot of third parties, it has to do with being able to manage a lot of contracts, and the turnover times could be high. So start working on your contracts so that you will have sufficient buffer time to be able to become compliant, because internal things can be done faster, but when it involves other parties, we know there are delays. So you should start working on that. So these would be my three takeaway for today. You're on mute.
Yeah, sorry for that. Yes, Andrew, thank you. Thank you so much for your session, Andrew. And it was, I'm sure many of all of our attendees would have found it very useful. And like you mentioned, contracts are a critical piece when implementing this regulation. So in the chat, I've actually dropped the website link of Zoho contracts. You can actually take a look at our website to know more about how this tool can help you stay compliant to become compliant and then stay compliant to PDPL. Right, you can also request for a demo right from the website to talk to one of our product experts to see how exactly can you use the software to implement PDPL for you and become compliant. So with that, we have come to the end of the session. Thank you everyone for joining the session. We hope it was clear and you were able to take out the value from the research. And